just a request for this status conference to address those in a reasonable time before our trial date. So I would ultimately defer to the state to address their specifics of their objections.
Okay, go ahead, Ms. Tuttle.
Thank you, Your Honor. Our objection to the defendant's notice pursuant to Criminal Rule 12.2 is that it was not sufficient and did not comply with the requirements of Rule 12.2. There was no specific information as to any prior incidents or circumstances upon which the defendant intends to offer evidence related to the conduct of the victim. Frankly, it doesn't mention the victim, Devin Quiggle, at all, anywhere in the self-defense notice. It mentions Tara Pichet, who happens to be the mother of our victim, but there is no reference or mention to anything that Devin Quiggle did prior to the shooting occurring. So that is our objection. It's not sufficient and it doesn't meet the requirements under Rule 12.2.
Okay. With regard to that, Mr. Bradley?
So the notice itself does address or reference a previous incident involving Devin's mother from some 2 weeks or so before, and I recognize that that does not involve the victim himself, but in the abundance of caution, I included that information. As it relates specifically to Devin Quiggle, these two are strangers. They've never met before on this particular day, and thus there is no information regarding any prior instances of conduct involving Mr. Quiggle himself.
Okay. So why would Quiggle need to be named?
So, Your Honor, our contention is that that's anything that happens before the commission of the crime. The crime charged here is a felonious assault with a deadly weapon being a firearm. There's interactions in the time period before the actual shooting occurs. It's the state's contention that that needs to be put in the notice.
What kind of time period? You talking about 30 seconds or 2 hours?
We're talking about maybe 20 minutes.
Okay.
So that conduct prior to...
On the road?
And in the parking lot.
Okay, but just so, because I don't know anything about this case other than the indictment and what's filed, okay?
Yes.
So these two don't know each other?
We don't believe they do.
Okay. All right. All right. So what is it you were looking for with regard to this 12.2 notice as it relates to Quiggle?
Evidence of his specific conduct.
Okay. During the 20-minute interaction?
Yes,
Okay.
or anything that may have existed outside of that may be unknown to the state but known to the defendant.
Okay. Mr. Bradley, as to that 20-minute roughly time frame?
Sure. You know, the state's discovery identifies a number of witnesses that describe various events that occur. I'm not conceding that it's 20 minutes, but for the sake of this discussion, yeah. Sure. That describe the events that led up to the actual shooting incident in the parking lot. So the state is on notice regarding the events and circumstances through their own discovery that they provided that identify the various witnesses. The only other information that we could theoretically offer would be to summarize my client's testimony, and I think in the state's response they concede that they're not looking for us to disclose anything that would be considered privileged.
Okay. So am I to presume then that there's other witnesses to whatever went on in that before they ended up in the Cleveland Clinic parking lot?
In parts and portions, we have some video evidence leading up to that incident, and we have witnesses after the shooting.
Okay. As it relates to before the shooting, though, doesn't the state need to be put on notice pursuant to that rule as to what the allegation is of the claim of self-defense? Like, and I don't know, I'm just
sure
making stuff up now, okay? But if a defendant, not Mr. Post, if a defendant is driving down 271 and says that the victim swerved in front of me and gave me the finger and tried to cut me off, and then a chase ensued, Isn't that like the self-defense claim that this guy tried to kill me by running me off the road? Wouldn't that need to be, say, this is why it was self-defense, or this is a reason?
So I'll break that down into several points. First of all, what ultimately is most relevant to the question of whether my client acted self-defense is what took place in the parking lot. Not necessarily the events in as the vehicles were traveling together on the roadway are not really germane to the question of whether he acted in self-defense. Okay. That said, Mr. Quiggle himself has provided a fairly detailed statement describing their interaction on the roadway, and we'll call it 2 blocks before they pulled into the parking lot where these events occurred, there was a witness that's identified by the state that describes observing and hearing the interaction between these 2 vehicles as that they were stopped at a parking lot. So it's not correct to suggest the state's unaware of the events and circumstances leading up to these 2 individuals ending up in the parking lot. And secondly, and perhaps more importantly, that any information that we would provide in furtherance of that description of these events would have to come from my client, and that's privileged information.
All right, but don't you have to reveal to the state any germane fact that leads to a self-defense claim? Isn't that the purpose of that rule? So that they know that, so we're not, the state knows whatever they know from other witnesses and from Mr. Quiggle, okay? But if there are facts beyond that you're using in your claim of self-defense, doesn't the state have a right to know that?
Well, no. Okay? Our position would be that that we put them on notice that he intends to claim self-defense. We inherent therein that, and when I think their witnesses identify that he was laying on his back on the ground and Mr. Quiggle was on top of him at the time the shots were fired. So to suggest they don't have notice as to what occurred here is not correct. And I keep coming back to this point, Judge, that if we're required to essentially summarize the specifics of his testimony, then that violates a number of privileged communications.
So is this rule overall unconstitutional?
The rule itself, no. Any interpretation that requires that the defense articulate information that's based upon information acquired from the defendant himself cannot be required.
Okay, so second sentence, the notice shall include specific information as to any prior incidents or circumstances upon which the defendant intends to offer evidence related to the conduct of the alleged victim. Okay. So that includes everything right up until it happens, right?
No, I don't believe that's correct.
What does that refer to?
So hypothetically, again, just using a hypothetical circumstance, if use you and me if you don't mind, if a week before I saw you at the bar and you flashed a gun at me and made some threat to me, and then a week later we're in the parking lot together and we have a confrontation, I as the defense would have an obligation to turn that over, information of the incident a week before, to the prosecution. And the reason being, Judge, is because the prosecution would have no way of knowing about that incident a week before at the bar. As it relates to the events immediately preceding the actual pulling of the trigger, I don't interpret the rule as requiring us to provide any information because the state's already on notice as to that. So anything else, I keep coming back to this, Judge, anything else that we would have to provide would have to come from my client. And there's no obligation for him to provide that sort of information until he takes the witness stand, because that's work product and it's privileged information.
So why doesn't the rule read that way?
Well, I think it does read that way. Prior instances and circumstances relates to something that occurred between the defendant and the victim prior to the incident at issue. Not prior to does not modify the 30 seconds leading up to the actual pulling of the trigger.
Ms. Tuttle?
Your Honor, the state, taking a plain reading of the statute as it is, believes that it involves any conduct of the victim prior to the offense, meaning anything that happened up and until the defendant pulled the trigger. That doesn't necessarily have to include statements made by the defendant alone. It doesn't necessarily preclude the defense from including information that was provided by the state in discovery. Rule 12.2 requires that the state be put on notice as to what specific conduct of the victim prior to the charged offense the defense is going to bring up.
So, two things. I don't agree with the characterization that's the plain reading. Prior incidents or circumstances is prior to the events at issue. And secondly, is that any summary, as the prosecutor is describing here, would necessarily have to come. I have no other witness other than my client. So any summary of information is going to come from my client, and that violates his right to remain silent.
In this hearing, the defense argues that revealing details of their self-defense claim would violate client privilege. The prosecutor disagrees, insisting that the rule demands full disclosure.
Not a prior incident. You're talking about any information coming from your client related to the immediacy of what actually happened, right? That's what you're talking about.
I'm saying that prior instances and circumstances contemplate something prior to the events at issue.
So if there's no prior incident between the defendant and the alleged victim, then there's nothing for you to give.
Exactly.
In any case.
That's right.
In any self-defense case.
So say, for example, where you have strangers. There is no prior instances.
All right, I understand both of your positions on that. What other issues are there with regard to this? What other objection do you have?
No other objection from the state regarding that, Your Honor. I think all of our arguments were encapsulated in that. The defense did raise a motion in limine regarding precluding the state from mentioning the filing of a self-defense motion or notice.
All right. Well, they have to prove beyond a reasonable doubt that it wasn't self-defense.
Correct.
So what are you suggesting, that they just not address that there was a notice of self-defense filed, or what?
So in this particular instance, that will be our defense at trial. And so, frankly, I have no issues with the prosecutor addressing the fact that we have raised the defense of self-defense. In theory, Judge, we could wait until the defense case in chief as to whether we would want to advance a self-defense case, depending on how the evidence came in. And in a situation like that, which is not this case, I think it would be appropriate to require that the prosecution not address the issue of self-defense. But that's an academic discussion. We need not bog down on that. In this particular instance, that is going to be our defense. There's no question about it. And thus, I have no issues with the prosecution addressing questions of self-defense in their case in chief.
Additionally, for the record, Your Honor, the state intends to ask this court for a self-defense instruction, whether or not the defense asks for it. We believe that the evidence in the case regarding the 911 call conforms to it.
Okay. I mean, that would be up to me as to whether there's evidence tending to support it. So
yes.
Regardless of who requests it, right?
forgive me, the prosecution just reminded me, part of the evidence is a 911 call from my client where he, somewhat contemporaneous to these events, described what happened leading up to the shooting. So again, the state, if by acknowledging that they think a self-defense instruction would be appropriate, inherent therein, they're on notice as to the circumstances.
We've already discussed that. I know.
Yes, but when she brought up the 911 call, I wanted to address
I know what
that.
you're talking about now. In furtherance of that academic discussion, though, in another case, if you were in a position where you didn't know, you were going to wait to see how it came in. They're still having to prove, right, in their case in chief, regardless of whether you're going to put on a defense or not, right? They're going to have to prove it wasn't self-defense.
Correct.
Okay. So
How would they do it?
So your objection in another case would be that they filed a notice of self-defense. Would that be what your objection would be? In another case, not this case.
Sure. We would comply with the rule.
Right.
File the notice.
Right.
We're now at trial. We've decided that, well, we want to see how the state's evidence come in, and thus we would not want the prosecution to comment on the fact that we've raised the defense of self-defense.
But they still have to prove that it wasn't self-defense.
That's right. But they don't have to
Say
comment
that-
that the defense
Okay.
is claiming self-defense here.
Okay.
To be clear.
You want to weigh in on the academic discussion?
Right.
Judge, it is our burden. The filing of that motion triggers
Right.
the burden on the state, so we would ask that we be allowed to mention self-defense.
Well, you have to. It isn't an issue here, so I want to put you guys back in law school a little bit. All right, anything else?
No, Your Honor.
All right, and then we're going to go discuss a date.
Nothing else.
Okay,
Would you like me to place the request for continuance from both parties on the record?
yeah.
So both parties have subpoenaed witness Brittany Loomis. I've had a chance to speak with the defense. She has gotten their subpoena and ours. She is unavailable for our current trial date due to pregnancy and some complications. So we would request that the court reset this for a date when she's available, as she is an essential witness. There is an indefinite speedy trial waiver filed in the case.
Mr. Bradley?
We would join in on that request.
Okay, so I'll grant that request, and then just have a seat in the hall, and let me go over with Maria what dates look like, and then I'll get you guys in, okay?
Okay, thank you.
After a long and heated debate, the judge decides to postpone the case until key witnesses can attend.